Good morning. It is Monday, October 13th, and there's been a lot of chatter on the internet and a lot of confusion regarding bond eligibility and mandatory detention while in proceedings, and whether or not bond jurisdiction will come back to judges. So right now, you may know that ICE is saying essentially, or DHS is saying essentially everyone who entered any which way to the United States other than those who entered with a visa are subject to mandatory detention and therefore are not eligible for bond, right? And this was really started in July of this year, and then we had some BIA opinions that kind of expanded on this ICE policy that anybody detained other than those who entered with a visa are subject to mandatory detention. And that has really handcuffed a lot of immigration attorneys because, judges are agreeing with the government's position that they don't have jurisdiction to issue bonds or to even hold bond hearings. And now there is this lawsuit in California, a class action challenging mandatory detention and those Board of Immigration Appeals decisions. And there is a hearing on summary judgment in this case on October 17th. So in 4 days, there is a hearing in federal court. Now, a lot of people are running with this and saying, oh, so on October 17th, bonds are coming back. No. On October 17th, a hearing will be held regarding the constitutionality, the legality of the court's interpretation and DHS's interpretation of mandatory detention. Now, there are a few different outcomes that could arise from this. Also, please take note that it is very unlikely that the decision will actually be issued on October 17th. It will probably be a matter of weeks, and it will likely be a written decision. But I've written down what the possible outcomes are. So the judge could agree with the plaintiffs that DHS's mandatory detention or their interpretation of the law is essentially unlawful. She could issue a declaratory judgment, and essentially DHS would have to stop classifying people who were not admitted to the U.S. as subject to mandatory detention, and they must now restore bond hearings and bond eligibility, okay? And it would reinstate immigration judges' jurisdiction to have a bond hearing. The court could declare the policy unlawful, but it could postpone or limit relief until further proceedings. We've seen that a lot lately. So they say, hey, this doesn't sound like it's going to be lawful, but I'm not going to issue a decision yet. We're going to have a full hearing on the merits, etc. The judge could side with DHS and hold that Section 235B, which is really what's at issue here, does apply to all not admitted individuals, and that the Board of Immigration Appeals interpretation is acceptable. In that case, mandatory detention will remain in effect, and it'll likely be appealed up to the Ninth Circuit. The judge might take it under advisement. They might hear, well, I think either way they're going to take it under advisement and issue a written opinion. But the judge might also ask the parties to address other things that come up. They might request supplemental briefings. So these are all the possibilities. This is what's happening on October 17th. Bond hearings are not coming back. This isn't like an automatic thing that bond hearings are coming back on October 17th. Now, that is a very optimistic and hopeful statement, and I do hope that the judge on October 17th agrees with the plaintiff's interpretation of the law, but even so, a decision will likely not be made on October 17th. So I just wanted to clear up kind of this chatter that I've been hearing. I've gotten some questions about it myself, and at first I didn't know what people were talking about, and then I realized that when they were saying bond is coming back on October 17th, I realized that people have been taking this hearing date and kind of running with it and twisting it into something else. So while a big decision regarding bond eligibility will be made, it is not necessarily coming back on October 17th.